So let's take a look. But the real point of today's show is not the Springtrap thing. I'm just going to cover that because it's the appellate court that looked at this case did kind of a broad historical review of American and Old English law on traps. So I thought it would be interesting for everybody. But the real point of today's show is that relying on the plain English reading of a statute can be dangerous because the courts can interpret things in and out of the statutes. And if you don't know how the courts actually interpret that statute, you don't know what it means. So, and again, this I knew this, but I read a lot of law, folks. So you can't keep everything in your head all the time. And my recollection of this was refreshed when I was updating our California law just this week and came across this case again. So let's start here with the relevant California statute that the defendant in this case, and I believe he was charged with, the person shot in the face was not killed. The youth shot in the face was not killed, but I believe the homeowner was charged with aggravated assault with a deadly weapon. Obviously a very serious felony. In most states, 20 years in prison with the gun sentencing enhancement. So it may as well be a manslaughter charge. And he's raising the legal defense of self-defense under California's justified homicide statute, which is right here. Let me pull that up. Here we go. Let's see if I can do it like this and still have it be, whoops, what I wanted to do. Okay, that should still be kind of legible. All right, so California Penal Code 197, justifiable homicide by other persons. Homicide, it says it's also justifiable because the immediate preceding statute, 196, is justifiable homicide by law enforcement. So just pretend we just read that section and now we're talking about justifiable homicide by other persons, not law enforcement. And it reads, homicide is also justifiable when committed by any person in any of the following cases. When resisting any attempt to murder any person or to commit a felony or to do some great bodily injury upon any person. So you can kill when you're resisting someone committing a felony. Or when committed, the homicide's committed in defense of habitation against one who manifestly intends or endeavors by violence or surprise to commit a felony. That was the defendant's, the homeowner's defense here, not the first paragraph, because he was not personally present, right? So he was not personally resisting a felony. His booby trap was resisting the felony, but not him. What he's arguing is the use of force by the booby trap, which would have been lawful if I had done it personally, was committed in defense of my habitation against the person who was manifestly intending or endeavoring by surprise, surreptitiously, to commit a felony, the burglary of the property. And based on the plain English reading of the statute, that's not a bad argument. I mean, it really was uncontested that these youths were committing a burglary of the home. They had burglar's tools. They were breaking things to get in for the purpose of stealing. I mean, it was the only credible. They weren't getting in there to rescue their cat who got into the house by accident. They were a little ambiguous, ambivalent sometimes in their own statements and testimony about, well, maybe we weren't sure we were going to steal something, but come on. They were there to commit a burglary, which is a felony. And they were doing it by surprise. They were sneaking in. And the statute says a homicide is justifiable when committed in defense of habitation against one who intends or endeavors by surprise to commit a felony. Seems straightforward enough. And that was the legal defense raised by this homeowner, raised by this defendant when he was charged. And let's see how that worked for him. By the way, I mentioned statutes. I mentioned case law as both being equally robust, real sources of law. There are also, of course, jury instructions. Now, jury instructions are not properly sources of law. They don't create law. Legislatures do in the form of statutes, and appellate courts do in the form of case law decisions. Jury instructions are not really sources of law, But what they are, and this makes them very helpful, is they tend to be an amalgamation, a combination of the statutory language and how the appellate courts want that language applied. Because the jury instructions are essentially created by the appellate courts, typically the Supreme Court of the state. So a little history here. In the old days, well before I was practicing law, but in the old days, the Abraham Lincoln days of practicing law, jury instructions were essentially drafted anew for each trial. Now, of course, there was a long history of similar cases with similar jury instructions. So it wasn't like they were literally starting from nothing. But in the course of, say, a criminal trial in the 1800s, the court would get to a part of the proceedings where they'd say, all right, defense and state, I need whatever you think are the correct versions of jury instructions. And the judge would read them, and then he'd come up with some combination of those that he thought accurately reflected the law in this case, as the jury should be instructed on it. But they did that for every case. And so you ended up with quite a bit of variance in jury instructions from case to case, including very similar cases on the facts. And this was thought to result in injustice. Defendants who were similarly situated, charged with similar crimes and similar facts, were getting different jury instructions, and therefore different legal outcomes, different verdicts. So one by one, the states all began to create what are typically referred to as standard or pattern jury instructions, from which the trial courts are supposed to choose their instructions from this list approved by the state Supreme Court and not make up their own. In fact, once the state Supreme Court has said this is the list of standard, pattern, approved jury instructions, the quickest way for a trial court to get reversed is to deviate from what the state Supreme Court told them to do. After all, the trial court, if it's reversed by the appellate courts, right? And the appellate courts are the ones who wrote the jury instructions they want used. So you're being literally insubordinate if you're not following their orders. They're your bosses if you're a trial court judge. So we have these pattern jury instructions, and typically the state Supreme Court would pull together a large group of legal experts. So academic experts from law schools, prominent defense attorneys, prominent prosecutors, maybe retired judges. And these folks would work together for a period of months, looking at the statutes, looking at the case law, and coming up with these standardized jury instructions that are a combination of the statutory language and how the appellate courts have said they want it applied. And it's standard. That's what every trial court has to choose the appropriate jury instructions from those that are approved. So that makes jury instructions very helpful for lay people because it is this combination of the statutes and the case law. And even more importantly, the jury instructions, unlike statutes and case law, are written in plain English. Statutes, well, they're written by the legislature. And let's face it, we don't typically send our very best to the legislature, right? So statutes are often not well written. Case law, court decisions, it is the definition of legalese. These are arguments written down by lawyers, judges, for lawyers, right? So court decisions can be difficult to work through if you're not yourself a trained legal expert. But jury instructions are intended for non-legal experts. They're jury instructions that will be read to a jury. Presumptively, no particular expertise in the law, so they have to be written in plain English, and they typically are. So jury instructions, combination of the statutory law and how the courts want that law applied to real people in real cases, and it's written in plain English, which is great. And as a bonus, it's very common for jury instructions to have the portion of the instruction that's literally read to the jury, and then also have something that's not read to the jury, but is intended to help the trial judge and help the lawyers really understand how the jury instruction should be applied. And these are typically called bench notes. So when I was reviewing California law, I was reviewing California jury instructions, came across the jury instruction for the use of force in defense of a dwelling, and it had a very interesting bench note that pointed out exactly what we're here to discuss today, that in fact, the plain English reading of the statute was not the appropriate interpretation of that statute.